Okay, great. All right. So, first of all, I want to apologize for being late. I had a little bit of trouble getting on, had an issue with connectivity, but we got that sorted out. So we're ready to roll. I wanted to give everybody a quick update on what is happening with the portal and the Trust Oversight Committee meeting that we had this week with the trustee and the claims administrator. So, again, there have been quite a few issues with the portal, particularly some of the issues that happened with the questionnaire. And these were both technical things, there was difficulty uploading documents, and also there was some wording issues that were problematic. So those, I think, have largely been resolved. I think there's a couple more technical glitches that are being ironed out. But what we're thinking is that we should be able to start uploading on a massive scale. Thus far, there have only been a few things that have been uploaded simply because, and this isn't just from us, this is from everybody, simply because there were problems with the portal in accepting large numbers of documents. It looks like that's been ironed out, so we should be able, and what I've told all of our people is expect to start pretty much uploading nonstop this coming week. So that's what we're hoping on. By Monday, we should be able to start uploading in earnest. And the goal is to have several thousand of these, not just from us, but from everyone within the next 45 days, at the latest 60 days. The goal is that if we can get a critical mass, if we can get at least several thousand, then they can do the budgeting that they're going to need to do, and they can figure out how much of the final award they're going to pay in the first payout. One of the things we've been talking about is that because they have to make sure that everyone is treated the same and the last person gets the same percentage of their claim as the first person, in other words, if everybody had to take a 10% discount and it was only 90 cents on the dollar, it's the same for everyone, they're going to withhold a significant portion. And they may do that in one of two ways. They may make kind of an initial disbursement where they maybe pay 25%, wait and see what they think the final number is going to be, and then pay the rest. Or they may wait on the initial payments and then pay a bigger portion of it once they have a better idea of what the total universe looks like. So that's why the budgeting is so important, and why they need to get that critical mass of claims. But again, it looks like the issues have been ironed out. The people who are on the Trust Oversight Committee are, in the same position we are. They're the people that have thousands of claims. And so all of us are planning on starting next week. So we should be able, again, to get in several thousand claims. So that's the main update that we have. Nothing really significant happened at the meeting. That was the big issue. There are still some issues about how certain things are going to be compensated. And so we're continuing to work with the trustee. We're actually preparing a brief on a couple of issues, and we'll circulate that to the other members of the TOC and then get that to the trustee next week for a couple of issues, and we'll see what happens there. Okay, let me look at the questions that we have. Question number 1, in your last update letter, you say the neutrals along with Yanni and the trustee are going to evaluate thousands of claims. How can they then be neutral on appeals going forward? So that's a good question. And I think it's important to understand that not all of them are going to be working on each claim. So you may have Yanni on one claim, neutral A on another claim, neutral B on a third claim. In the event that there was an appeal, then it would be a different person that heard the appeal. So let's say that you disagreed with Yanni's interpretation or estimate rather of what your number should be. She awarded 250,000. You say, no, this should be 300. I want to appeal. You could go to a different neutral. So you would get neutral B or neutral C. Same thing if you had an award that was issued by neutral B. It would not be neutral B that would then be sitting on the appeal. At the first level appeal, it's a single individual, so it would be some other neutral. In the event that you then decide after that second neutral takes a look at it, in the appeal, they're wrong as well, I want to go to the next step, you can then do another de novo in front of a panel of 3. Those 3 would be separate than the first 2. So if Kathy did the first one and you said, no, that's incorrect, then neutral A did the second one and you also disagreed with that, you could then appeal to a panel of 3, and that would be neutrals B, C, and D. Neither Kathy nor neutral A would be on it. So that's how it's being set up and how it's envisioned. There should never be a time under the protocol where someone who looked at it at a previous iteration, so on a previous level, at the initial level or the initial review, would be on it in the final review. Okay, second, PG&E share price has been in the low $9 range for some time now. As I understand it, the price must get to 14 to fulfill the $6.75 billion payment obligation from PG&E. That is correct. How much time will Morgan & Stanley have to sell the shares it manages for the trustee? Is there a deadline for selling all of them? Again, that's another very good question. So the way it works is that there is absolutely no timeline for them to sell it. It's going to depend on when the trust needs the money. Right now, the trust has well over $5.3 billion in cash, and they're earning interest on that, so it's getting to be more every day. The trust earns about $50 million in interest a year on that cash. So that cash is going to be the first that's going to be paid out. When the initial payments are made, they're going to make that payment out of that cash. At some point, though, probably within about 6 months, they're going to run out of the cash, and then the trustee, along with the financial advisors, are going to have to make a decision as to how much of the stock they're going to sell. They're never going to get to a point where they sell all of it at once. They did some financial projections for us, and they talked about how much you can sell in any lump without fundamentally altering the price. In other words, making it go artificially low. And it's a fairly limited number. So there's going to have to be several times in which the trust sells those shares of stock in order to make it most advantageous. So what they're going to do is as they get closer and closer to that time when they're going to need the money, they're going to look at the share price and decide, does it make sense to sell or does it make sense to borrow against the shares? If, for example, it was at 9 and it's gone up to 13 and it's been steadily trending up, then in all likelihood, they would wait to sell it or sell a small amount as opposed to selling a large amount. If it's static and it hasn't moved much, then my guess is they would sell a more significant amount in order to raise the cash. It really is going to be a judgment call. The hope here is that once we get through fire season and once the earnings projections come out for next year, the stock price is going to jump substantially. And if it does, then the stock would be worth either 6.75 billion or hopefully more. The hope is that it gets into the high teens, in which case there would be an extra billion, billion and a half, maybe 2 billion that would be available to pay everybody. But nobody has a crystal ball, and we'll just have to wait and see. So that's what's going to happen. We'll know more as we get a timetable from the trust as to when they anticipate making those first payments and then how much those payments are going to be. If the first payments they make come out to 3, 4, or even 5 billion, then they're going to need to raise money and they're going to need to sell the stock. On the other hand, if they pay out 1 to 2 billion in that first group, then they'll have more time and more flexibility in terms of what they're going to do. The other thing that they can do instead of borrowing against the stock is that there's another 1.35 billion in cash that's going to be paid into the trust, and it's very easy to borrow against cash. So if you borrow against the stock, you're going to have to pay more interest. If you borrow against cash with a specified time period as to when the cash is coming in, then you can pay less in terms of interest. So those are things that the financial experts are going to have to work out. Ultimately, the decision is going to be made by the trustee. We, as the Trust Oversight Committee, are allowed to weigh in and to give our recommendation. We can't overrule the trustee when it comes to something like this in terms of selling stock. Although if we felt that it was a fundamentally bad decision, then we could move to have him removed. But I think, speaking from my perspective, I would want to see where the stock is and what the projections are for the future before I made any decision on whether or not to sell or whether or not to hold off. So that's a very long answer to that question. Sorry to ramble on. Those are the only two questions that we received in writing. Chewy, do you have any more in the queue?
I do. I have just one here in the chat. It says, how many processors are working on the trustees team reviewing claims?
There's roughly 200 people that are working on it, and that's separate from the neutrals, but they all have different jobs. There are people that just do data inputting. There are people that check the numbers. There are people that look at the actual claims themselves and say, okay, the average cost per square foot to rebuild a home in this zip code is, let's say, $300 a square foot. This person has submitted a report for $325. So it's within, the normal margin of error. On the other hand, if the average cost per square foot in a particular case is $300 and you submit a report for $600, that's obviously going to be red flagged and they're going to look more closely at it. So again, everybody has a different job, but there are roughly 200 people that are working for Brown Greer, which is a law firm that does nothing but analyze data and come up with what they believe are appropriate settlement amounts given all of the data involved. So again, what they would do is say, in this particular zip code, the cost to rebuild is X, the average claim for trees and landscaping is Y, and then they look at the specific reports that are submitted to see if they're reasonable given what the average ones are. If they are, then they let the either the trustee, the claims administrator, or the neutral, whoever's making the initial determination, know that. If they're outside of it, then they let them know that. And then in all likelihood, the person making the evaluation of the initial claim will ask for more information, and we'll have the opportunity to explain why, in this particular case, we're justified in asking for something that is significantly more than the average. So that's how we anticipate it working, and that's how the process has been designed.
Thanks, Jerry. I do have a question here. Is there an update on the 1099 issue, the tax issue?
Yeah, we had a discussion about that, and there were several ideas that were, kicked around. The tax attorney for the trustee is still of the opinion that a 1099 needs to be given in two circumstances. One is where there is emotional distress with no physical injury of any kind, so not even smoke inhalation, burned eyes, anything like that. The other is where there is rental income. And she believes that in those two circumstances, a 1099 needs to be given. We believe that it's not necessary and that there can be a lump sum that is paid that is not broken down. And we have retained a tax expert, a gentleman named Robert Wood, who is a tax attorney in San Francisco, who's very well regarded and has written a number of articles and opinions on this subject. He's going to give us an opinion that we're then going to give to the trustee and his attorney to see if we can get them on board. But that's something that we know is critical for everyone. We know you do not want 1099s, and so that's a priority for us.
Thanks, Jerry. There's a question here about who is paying for the 200 plus, the team of 200 plus on the trustees.
Yeah, that's coming out of the trust. That's why the trust administration expenses are what they are, because they have to pay for that. Now, the way that we have set it up, we believe that the interest on the money is going to pay either the entirety of the trust expenses or the vast majority. But obviously, we won't know for sure until the end.
Thanks, Jerry. We can open it up now.
Okay, so those are the only questions that we received either in writing or emailed in. Please let me know what questions you have. Let's open it up.
You know what? Sorry, Jared. There's one just came in. It says, in the past, you said we would expect 70 to 80% in the first payment. Now you're saying it could be only 25%. Can you explain, please?
Sure. What they said today is that, not today, yesterday. What they said yesterday was that they may do it in terms of, they may make 3 payments instead of 2, depending upon how much information they get. If they do it that way, then the initial payment will be much lower. So that's the reason for it. It all depends upon how much information the financial analysts have when they make the first distribution. If they have enough where they're comfortable with a range of how much it's going to be, then they'll pay a lot more. If they don't, and they make the payments very early, then it probably will be lower.
Thank you, Jerry. I think now we can open it up.
Okay, who's got questions?
Looks like Brian Mills.
Okay.
Okay, sorry, I had it muted. Just 2 questions really quickly. One, I received a questionnaire by email, and I just want to make sure, was that just for informational purposes, or is that the actual questionnaire that we're supposed to be turning that's our official statement of emotional loss and so forth? Okay,
to answer that question, that is the questionnaire that's being used, but that was sent solely for informational purposes. A lot of people want to take a look at it. We've had numerous requests for people. So we put it on our website. We gave the link to everybody who wants to see it, where it's on the Fire Victim Trust website. And we sent it out to everybody via email. So anybody who's curious can look at it, but it is 100% for informational purposes. We'll fill it out for you based on the information you gave us. We just wanted to get that to you because several people had requested that we send it.
Okay, so we'll get an opportunity to review that information that was filled out for us and add to it or adjust it as necessary before it's officially turned in on our behalf?
Well, the way that it works is that unfortunately we can't print it out. There will be a verification that will be sent to you, and so you have an opportunity to look at it, but it's a convoluted process. And so we'll have a better idea of exactly how it's going to work on the call next week, because this is one of the things they're still looking at. They've gone back and forth in terms of whether we have to sign it or whether the claimant has to sign it. So hopefully we'll get that ironed out and we'll have a definitive answer next time.
Okay, great, thanks. And I did type a question in the chat too. I don't know if Chu was going to bring it up, but I'm just trying to determine if it's necessary for us to get the arborist involved in our claim. So is there just kind of a good metric or rule of thumb to think of when we should not expect the standard claim to be high enough for us, whereas it makes sense to get the arborist involved?
Well, if you lost trees, then we always have an arborist do a report. I mean, I suppose if you had one tree that you lost and it was minor, we probably wouldn't. But if you had any kind of a significant loss, then the arborists do the report. And those reports are pretty cost effective because we give them so much business. They reduce the rate quite a bit. So they tend to be worth it to do. What type of loss did you have? Was it, half an acre, several acres?
Mainly tree. So we had 3 mature palm trees, a couple mature oaks, some other specimen trees that our insurance will only give us like $500 a piece for.
Right. Yeah, no, that has to be done by an arborist.
Okay. So what's the process for getting that done, or is it done automatically? Is every lot
Yeah.
determined? Okay.
What happens is we have the initial intake process, and the questions that we ask in terms of your basic losses are designed specifically so that we know which experts to order. So as long as you've had communication with our office and provided that general information, a report would have been ordered. And then if you'd like to see that, all you need to do is email and request it, and we can get that to you.
Okay. So anyone specifically I should email for that? Doesn't matter, or?
I think the best person to email for that is Serena. She is the paralegal who is in charge of the damages on this case. So it's just Serena, SERENA @slffirm.com. And all of our emails are just first name and then slffirm.com.
Okay, thank you. So, and I can just tell her the property address. That's all that's really needed, or?
Yeah, just tell her your name and the property address, and she can let you know if it's been completed. If so, then she can send it to you.
Thank you very much.
Sure. All right, who's next?
Hey, Jerry, it's Brad Schofield. How you doing, sir?
Good, how you doing?
Good. Hey, you made a statement. So how many people, you said how many people were in the trust, not committee, but in the actual trust doing it? You said 200 people approximately?
Oh, you mean that are working for the trustee to process the claims? Yeah, about 200.
So 200, and then you made a statement that that you're hoping that the interest on our money is going to cover their expenses. And you said that's $50 million a year. So we're paying the trust about $50 million a year?
Well, no. When I said the expenses, what I meant was everything. So not just those individuals who, for the most part, are pretty inexpensive. The financial advisors are much more expensive, the investment bankers. So the hope and the way that we set it up is that the interest that is earned on the money would pay for everything that the trust incurs. So the trustee, the neutrals, the 200 people that work there, the investment bankers, Morgan Stanley, that's the goal. Obviously, we wouldn't know for sure until we see the end, but investment bankers and top-end financial advisors, the amount those guys charge is unbelievable. And it's not like we are the trust, because we didn't hire them, the trust did, but it's not like the trust hired particularly expensive people. They actually got a discount, for lack of a better term, because of the fact that this is basically a public interest, but it's still just ungodly in terms of how much they charge.
Well, I mean, so as claimants, don't we know how much can't you tell us how much they're charging?
Yeah, absolutely. I can get you the fee schedules. And if you want to see those, no problem. I can let you know what they are. Off the top of my head, I don't know. I just know it's a lot. Right.
I mean, I think it'd be nice for us all to see that. I mean, I mean, to me, it's like $50 million. If we're paying these people $50 million, wow, that seems a little steep to me. I mean, coming from our little town of Paradise, $50 million is a ton of money. And,
oh no, understood.
And I'd like to see where our money's going and how much we're paying these people.
Absolutely. Yeah. Just the best thing to do is just to send me an email. And what I can do is let me know specifically what you're looking for. I will get that information from the trust and I will send it to you.
Thank you.
Sure. All right. Who's next?
Jerry, I got a question.
Go ahead.
So if I got this right, if there's 3 payments, let's say I settle for 200,000 or whatever it is. Okay. So, and that will be divvied up in 3 payments. Okay. At different times. So so the last payment, if PG&E stock goes up, it will be more than the other 2?
Yeah. So that's the thing. And there may not be 3, there may only be 2. The reason that I brought that up is that the trustee had mentioned in our meeting yesterday that it might actually be 3 instead of 2. Again, it's going to depend upon how much information the financial analysts have, because they have to be able to give the trustee a guarantee that he's not going to overpay. And so the trustee is trying to balance basically what the trustee wants to do is get as much money to the victims as quickly as he can. And so what he said yesterday was, I'd planned on making 2 payments, where the first one was pretty substantial. It may be, if we don't have enough information where that I can do that and still discharge my fiduciary duty, what I might do is just give out a smaller amount very early so that I can get some money out the door and into the hands of the claimants earlier, and then make 2 subsequent payments as opposed to 1. We don't know if that'll happen, but it may happen. In terms of your other question, yes, all of the money that is generated by the stock is going to be given to the claimant. So if we get to a point where you're able to get paid 100 cents on the dollar and there's still money left over, then what we're going to petition the trustee to do is to award punitive damages and to give those out on a pro rata basis.
Okay, thank you, Jerry.
Sure. Okay, who's next?
I have a question.
Yes, please, go ahead.
If we're not required to fill out a 1099, does that mean that we have no tax liability? 1. 2, if we have tax liability, do we need a specialist in this field that knows the circumstances, since it's such a unique lawsuit and et cetera, et cetera?
Yeah. Yeah, so no, the fact that you don't get a 1099 does not have anything to do with whether or not you owe any taxes. We try to set it up so that they do not give you a 1099 so that you have more flexibility. And to answer your second question, I would strongly recommend that you talk to a CPA who is familiar with this area. We do have recommendations. We have one that we've worked with in the past who many clients have been happy with. A lot of times you can talk to your normal CPA, whoever does your taxes, and they'll be able to answer it. But, it's just up to you. Maybe you start with the person you normally use. If they can't answer it, then you try someone else.
Okay, thanks.
Sure.
Jerry, I do have a question here in the chat. It says, how many claims are there in total?
There are 24,000 properties. And so when you think of claims, that's, I believe, the best way to think of it. So if you think of the 24,000 properties, that'll give you a good idea of how many the trust is going to need to get through.
Thank you. And there's another question about, will we be able to review anything that's submitted to the portal before you upload? Will we have the password?
No. The way that we do it is this: for people who want to review before anything is submitted, please let us know. And you can email Chewy, you can email Serena, you can email the attorney you're working with, whatever is your preference. Please let us know. We'll make a note in your file and we'll make sure to get it to you. It can take longer that way because unfortunately it's not designed to be shared that way, but we can absolutely do that. Any other questions in the chat, Chewy?
I do not have any more in the chat.
Okay. All right, let's open it up to the big board.
Hello, am I on? Can you hear me?
Yes, is this Ms. Bremer?
It is. Okay,
Okay,
so
go ahead.
I thought I did send a chat to Chewy, but obviously I'm not very savvy.
I'm the same way. Don't worry about
I
it.
know. It's a mess.
Yeah.
Okay, so Barry from your Matt construction group called me some time ago and gave us a fire loss estimate. And it
Okay.
ended up being higher than our insurance quote when we had our insurance quote done like in January, February of 2019. Now, the Hartford did give us a pay out. You've never settled. They did give us a pay when we bought a home here in Arizona. But like I stated before, that's because we did not want to rent. We did not want to have the possibility of being booted out and not having a place we could live. We thought we might like it here. We hate it here. It's hot, it's miserable, there's no trees. We want to rebuild, but now we're in that quandrum that prices have escalated, and we no longer, if we sell this house, have the funds to buy a house in Paradise. So we sort of kind of waiting for this settlement.
Sure.
What do we do now? I mean, my insurance company told me 2 years. That comes up in November. They told me they're not going to give me any more content insurance unless I buy everything back and give them receipts. They feel they've paid me out, but they haven't.
Mhm.
I think we're in a hurry up and wait like everybody. What do we do?
Well, that's, yeah, no, and unfortunately, that is a situation a lot of people find themselves in. One of the things that the trustee did last week, which I really appreciated, was contacted the insurance commissioner and asked him to use his influence with the insurance companies to extend that out another year. And he said basically almost verbatim what you're saying, which is to the insurance commissioner, who is very sympathetic. He actually really has been good on these issues. I've been impressed with, I don't like everything he does, but I've been very impressed with the way that he's advocated for fire victims against the insurance companies. And what the trustee said to him was, look, because of the bankruptcy, these individuals who were victims of these fires through no fault of their own have had to wait an extra period of time in order to get the funds that they need in order to satisfy the requirements of their policy, whether it's whether you have a replacement personal property, as you were describing, we have to go out and buy them and give them replacements, or whether it's that extra rebuild. A lot of people have an extra 25, 50%. If you actually rebuild and incur the cost, then you can get it. And so what Justice Trotter said in his letter to the insurance commissioner is that he requested the commissioner to, he can't technically order, but to strongly urge the insurance companies to extend it for victims of these fires. When they've done that in the past, a lot of insurance companies have voluntarily complied. So that's going to happen, and we'll have to see. Not all of them will do it, but we do believe several of them will. For those that don't, then you would be in the situation where you would be allowed to recover from the trust for those types of things. In other words, as we've talked about, the amount of insurance ordinarily is the policy limits, and you have to exhaust them. However, if you were unable to exhaust and the time period for doing it has run out and your insurance company will not give extensions, then the trustee is going to deem that having been satisfied, and you can recover that balance that you didn't get from your insurance company from the trust.
So with that said, do I need to contact the Hartford, who's our insurance company, and ask them if they will extend for me? Do I need to have that verbally done or written or something?
Yes, you really should. And remember, and this is true for everybody, you want to get the most you can out of your insurance company for two reasons. Number one, it affects what you can get from the trust. But number two, all that money goes to you. When we get money for you from the trust, you have to pay us for doing that. When you get money from your insurance company, it all goes to you. So again, I would encourage everyone, try and get the most you can out of your insurance company, because if you get the same amount from the trust as you would get from the insurance company, then you have to pay us, and it's going to reduce the total amount available to you.
Okay. And once again, we're all in a hurry up and wait to see what we can do in the future.
No, totally understand.
We don't know.
But yeah, no, and I'm sorry for interrupting. I totally get it. It is a hurry up and wait right now. But what you can do in the interim is reach out to your insurance company and try and get that agreement to extend it. And all you have to say is, here's the situation. we were not able to do this because we couldn't get the money due to the fact that PG&E declared bankruptcy. One thing I'm trying to do is to get the trustee to release the letter that he wrote to the insurance commissioner publicly, and that way all of you can attach it if you do reach out to your insurance companies. Right now, he's still in negotiations with them, with the insurance commissioner, so he's not going to release it publicly. But once that gets done, then he will, and then we can go ahead and have everyone send it to their insurance company, and it will provide some additional support because the trustee, who's a retired appellate justice, will be saying this is what should happen given this unique set of circumstances.
Thank you very much.
Sure. All right, who's next?
Jerry, I have a question here about emotional distress. There's a question about several issues affecting the marriage because of the fire, and there is a recommendation from the primary treating physician for counseling therapy, but there's no appointment yet that they have gone to. How do they proceed with the claim if they haven't gone to the actual counseling yet?
Yeah, so when you're talking about issues with marriage, and you know, at least if you're like me, anybody who's been married has had issues in the marriage. I think that is just the universal condition. And I really recommend that is not something that you make an economic damages claim for. So you don't ask for the cost of counseling. You don't open up the records of the therapist, because if you ask for the economic amount, then you have to provide authorizations to allow the trust to look at what the therapist says. And the reason for that is that in any marriage, there are going to be issues. And while stress negatively impacts relationships, and it can have a very negative impact on a marriage, particularly an incredible stressor like this, there are always other issues. And what I've found is that the natural tendency of the people reviewing it are to say, well, you know, these problems pre-existed, or the real problem is X, not the fire. Whereas if you just make it more generic and you put as part of the overall mediation narrative, you know, due to, and explain what the circumstances are, you know, going from living in a 3-bedroom home where everyone was comfortable to being crammed into a smaller, or whatever the particular stressors are, you can say that's caused a tremendous amount of strain on our marriage and it's been difficult for everyone. That's something everyone can understand. They can factor that in, but you don't have to worry about the other issues that may come up if you make a more formal claim. Okay, what other questions do we have?
Jerry, hi. This is Teddy Waters from Magalia.
Hi.
Can you hear me?
Yes.
This morning, we got a phone call from someone from your office saying that we had an appointment coming up next Thursday to speak to them about acuity scheduling.
Mm-hmm.
Could you tell me what that's about?
Yeah, so that is something that we use, and I think basically what they're going to do is to kind of walk you through what's going to happen, and set up times to talk to get all the information that they need in the case.
Because we've already gone over everything with someone else, and I didn't know what this was actually concerning.
Okay, so as far as you know, you've submitted everything. There's nothing else, because usually the process you're talking about happens earlier on. If you've already submitted everything, that's not the normal process.
Yes, everything is in.
I think the best thing to do is to reach out to Serena, because again, she's the paralegal that coordinates the damages aspect, and she can take a look. It may be that it was just a glitch and that you were not supposed to get scheduled because we already have the information, or it could be that we're missing a piece, and so that's what they're reaching out about.
Okay.
Okay.
Okay. I'll just wait then, and next Thursday we'll find out.
Well, or I think, just so you can, short circuit that and not have to wait. If you want to call the Sacramento office or email Serena, she can answer the question for you and get you in touch with the right people.
Okay. Will do. Thanks a lot, Jerry.
Sure. Okay, who's next?
Jerry, I have a question here in the chat. It says, if a claim is submitted jointly by a couple, yet have individual claims, how are the funds dispersed, separately or jointly?
If a claim is submitted jointly and it's about, common property, then there's going to be one award. How that is divided up, typically what we do is, as part of the resolution process, we prepare what we call distribution worksheets. And what they do is they say, okay, here's your gross award. Here's the amount you're paying in fees. Here's the amount you're paying in costs. We itemize everything so you can see it and make sure you're comfortable with the numbers. Once that's done, then we ask you how you'd like to receive the money. Typically, husband and wife will just say, give us a check in both of our names. But sometimes people say, well, we want X amount to go to Mr. Smith, Y amount to go to Mrs. Smith. Whatever it is, as long as it's not illegal, which, you have to go a long way to make something illegal. As long as it's legal, we're happy to distribute it however the people want, as long as we have that signed off on by both parties. All right, who's next?
Thanks, Jerry. It says, how is the distribution applied to my children? I have 2 kids in the claim.
Right. So with a child, there has to be an approval. In this case, it won't be by a court. It'll be by one of the neutrals, but they have to approve the amount that the child receives. Typically, because most children don't own property and it's just limited to emotional injuries, the amount they receive is much less. So if the bulk of the award is going to go to the parents for the loss of, the home, the landscaping, those kinds of things, there is an award that goes to children, but again, typically it's much less. So that money, if it's above $5,000, has to be put into a blocked account. So let's say that the award for the children was a net of $10,000. You would set up a blocked account, and there's a process for doing this, and the money goes in, and it cannot be accessed until the minor turns 18 unless there is a court order. If, for example, there's an emergency and the child needs the money, then you can put it then you can petition the court to get access to it. The other option is to do a structured settlement, although typically for smaller amounts, that's not something we do because the generation fees eat up too much of it. On the other hand, if you have a child with significant injury and you have, $100,000, $200,000, $500,000, then you probably are going to want to put it into a structure because you'll earn more money than you would on the interest. The structure is basically an annuity, so it's not paying out a ton of money, but it'll pay 2 or 3% per annum, as opposed to the blocked account, which I think now it gets like 0.25%. It's very low. So that's the answer to that.
Thanks, Jerry. And it says here, for a family claim, should there be one narrative for the whole family or a separate narrative for each family member?
Typically, it's best to do one narrative as long as everyone's included. There are times when that's not feasible. If, for example, the family members get split up, then it makes more sense just to do 2 separate ones. But it's kind of a case-by-case basis. Generally, we'll do one unless, like I said, there was just an extraordinary difference in terms of what the people experienced. For example, we've had times when, husband and wife flee together, get separated because they're in separate cars. One of them manages to make it out without too much trouble. The other one has an incredibly harrowing experience. You're going to have 2 different narratives there because the experiences are so different.
Thanks, Jerry. There's a follow-up question regarding the family claim. It says that the children are now 18.
Okay.
How
Well,
does
then they
that-
don't, oh, I'm sorry to interrupt. They don't need a, we call them minors comp, which stands for minors compromise. They don't need a minors compromise approval if they are of the age of majority, 18 years old at the time of the settlement. They only need it if they're under 18.
Thank you. It looks like Brian Mills has a question.
Sure, go ahead.
Yeah, I was just wondering, kind of a follow-up to a previous question about the uncovered, let's say, rent from insurance. We're feeling pretty certain that before we get our house fully rebuilt, we're going to run out of our insurance coverage for rent. Do we just wait until the very end, we've moved into our house, and then we submit to the trust the amount that wasn't covered? Does it matter if it's, you know, well after the first distribution or anything like that? Is it, you just continue to accrue this stuff, or should we just estimate how long we're expecting to be out?
Yeah, the second one. What we do is, because we only make the one submission, I mean, we can amend it, but that's not as efficient. We want the trustee to believe they have all the documents so that they'll make the evaluation. So what we would do is just project. And if you're rebuilding your home, for example, and your contractor says it's going to be done in September, then we'd add a couple of months because, you know, they're always overly optimistic. And we would say, okay, based upon all the information, it looks like it's going to be November. So we're projecting the alternate living expenses out to November. The insurance is, let's say it's 100, and they're going to spend 120,000. So the balance is 20, and that's what the trust should pay.
Okay, so how do I arrange that at this point then?
Just tell the person that you're working with what it looks like, and if you haven't spoken with anyone, then that's a question that's going to be asked. You can send it in to us. You can always send any information to info@slffirm.com, and it'll get to the right person. You can call, whatever's most convenient for you.
Okay, so I can just send it in, I can just send to info.com my address and name, and here's the situation.
Exactly, and what the information is. And that really is the easiest way. If you just send it into info, then what happens is the paralegals who are in charge of each part of the project will look at it, put it into the file, and then the attorneys that are working up the claim can do it that way.
Okay, great. Perfect. Thank you.
Mm-hmm. All right, who's next?
I have a question here, Jerry. It says, since our property is in a trust, and obviously my wife and I do not expect to triple dip, how will our claims be submitted, including the emotional distress?
Sure. That's very common. I'd say about half of the properties we have are held in trust. So we just submit all of them at the same time. We'll submit the names of the individuals who have individual claims and the trust, and then the money will all come together. There are certain exceptions to that. There are times where this really only happens with high-end trust. It's not going to happen for a typical couple that put their assets in a trust. But, you know, there are some people that have trusts on, usually this is on very high-end properties, maybe, you know, several hundred acres, that have numerous beneficiaries. Then you have to be a little bit more careful, because you have to make sure that you're doing right by everyone in the trust. But here, you know, 9 times out of 10, you're just talking about a standard trust that people put their assets in for protection, and then we just submit them all together.
Thanks, Jerry. I have a question here about the narratives. It says, how detailed and how long do you plan the narratives to be? 1, 2 pages, or how much more? And is there a standard template?
Yeah, we've learned from trial and error that people generally don't read that much. So we try to keep the narratives, I mean, we try to make them really, you know, kind of classic Hemingway. You want it to be very direct, not a lot of adjectives, and just really describe what happened in as short a space as possible. That said, there are times where you have to be much longer. I mean, we really try to keep them under 2 pages, but, you know, there are some extraordinary circumstances where you have to make them longer. But we try to keep them as short as possible. Basically, what they're looking for are kind of the facts. It's kind of like Sergeant Friday. You know, they want to know how close you were to the fire, what your evacuation was like, and then what your life was like post-fire. Were you somebody who was lucky enough to get into a very similar situation and had enough ALE? Were you somebody who unfortunately struggled quite a bit? Those are the things they want to know, how your life has changed. And then the other two elements are how your enjoyment of your property is going to be affected. For example, did you previously live on a heavily forested property that now looks like a moonscape, so the enjoyment you had from the property is not there? And then cherished possessions. We put that in. But we try to keep them under 2 pages. Obviously, sometimes they go longer. But again, what we found is that whether it's defense attorneys, mediators, neutrals, people can always say, oh, of course I read everything, but it's just kind of human nature. After a couple pages, unless it's really engaging, they tend to zone out. So we try to keep it as short as possible.
Thanks, Jerry. I have a couple of emails here. One of them says, do they take into account that the 2017 fires have obviously waited longer than Camp Fire as when it comes to the emotional damage? 3 years is devastating.
Yeah, so one of the components of emotional distress, and technically this is nuisance, but the non-economic damage is how long you've been affected. And, you know, obviously, if you're one of those people in Butte whose home was destroyed and, you know, you're still waiting to get paid the money you need to rebuild it, that is, you know, waiting 5 years is very different than waiting 1.5 years. So it's a factor that they look at, but it's not the definitive factor. I mean, they're going to look at all the circumstances, you know, what your waiting period was like. Were you in a similar situation? Did you struggle? Did you have to be in a significantly inferior situation? How long you waited? All of those things are things they're going to consider.
Thank you, Jerry. And another email here says, are fire survivors without insurance an easier process for the trust?
Yes, they are, simply because that whole element doesn't have to be dealt with. And with insurance, because as most of you know, those of you who have insurance, they very rarely give you just one check. Typically, it's, you know, you get this check, then you get that check, you get all these different things. And the trust has to make sure that they get these amounts exactly right. So it's going to be easier for them to process somebody who's uninsured than somebody who is insured.
Thanks, Jerry. That is it for the chat and emails for now.
All right, back to the big board. Who's got questions?
Jerry?
Yeah.
Hi, it's Cynthia. I just, if I know you've referred to in the past, that I don't know if it's been addressed subsequently, but I know you were still waiting for the trustee to determine, at least I thought you were, what their formula was going to be for the attorney fees. I don't know if that's occurred yet or not.
No, that's something that we're briefing. In fact, my associate who's on this just sent me the brief earlier today. I'm going to circulate that to the other folks in the TOC and some other interested parties, and then get it to the trustee. The trustee is at this point under the belief that it has to be done on an hourly basis as opposed to a percentage, which we think would be very inequitable. And so we're petitioning to have that altered. I mean, that's not a decision that's going to be made for a while, but one of the things that he did yesterday was say, these are the cases that we found, and this is what we believe it says. None of us on the TOC agreed with that, so we're preparing a brief that we believe sets forth the law that he can rely on to make it based on a percentage, and we'll see what happens.
Thank you.
Jerry, I had a question, and that is on this summary sheet, if there's no insurance, should we put that there's no insurance on the summary sheet?
Yes, please.
Thank you.
Okay, well, we've been going about an hour. Does anybody else have questions? All right, if there's, I mean, we'll check again before we sign off, but if there's no more questions, then let's definitely do this again next Thursday. Let me check one more time. Chewy, any other questions?
Nothing else. Just a reminder. I think you hit on it, but it would be best if anybody has questions or wants to submit additional documents that they have. I think info@slffirm.com would be the best option. We'll make sure to respond to those as soon as we receive them.
Okay. All right, everybody. Thank you, and hopefully we'll have some more information for you next Thursday. Take care.
Thanks,
Thanks, Jerry.
Jerry.